Mr. Justice, our ambassadors group here in Richmond has been discussing judicial issues all week, so we have some questions from our local ambassadors leaders. So we'll start with one right here.
Good evening, Justice Breyer. My name is Tierney, and the first question from Richmond is, some say that among the most pressing constitutional issues facing the nation is the growing power of the executive branch. For instance, we have been engaged in hostilities in Iraq for nearly 4 years, and Afghanistan for over 5, without a formal declaration of war by Congress. Presidents use recess appointments and executive orders on other fronts to circumvent the oversight and approval process by Congress. What do you think of this expansion of executive power, and what is the judiciary's role in maintaining the institution of checks and balances?
The last part of your question is easier for me to answer, because it's a good question, and you ought to come and see the court. I'd like you to come and see it. Why? Because you see the 9 people there, and you think, well, isn't it amazing they're just 9 people? Now, why is it that they have anything to say in this? And the way I think about it sometimes is that Congress and the judges over here and the president are in a system. It's like sort of the ship of state, and it gets too far in one direction, and lo and behold, these other institutions pull it in the other direction. And every time you think it's going to capsize, you see something go on which makes you think, wait a minute, there's no one branch that runs the country. There's several branches working together to keep this United States government on something of an even keel. And that's why I told you, for example, about the case of bin Laden's driver, because I wanted you to see that sometimes when the president has a view, and it's a perfectly reasonable view, but it might not be, in the opinion of the courts, the legal view. And then Congress might take action, or maybe the courts will. The best example, not in your lifetime, not in your lifetime, but in mine, the best and most famous example of that, Brown versus Board of Education. We had in this Constitution a provision that says every citizen, no state, it says, shall deprive any person of equal protection of the law. Well, you can't remember that, but your parents might. And they would look around. For 80 years in this country, we had a system of legal segregation. And I got some pictures of that to show to a few of my students. And they couldn't believe it. Because if you thought that was equal protection of the law, you must be blind. It wasn't equal, and it wasn't protection. I mean, that was a huge problem. Eventually, in 1954, Thurgood Marshall argued to the Supreme Court, and the Supreme Court unanimously agreed that that system was contrary to the Constitution. Now, after they held that, it still took a long time before that legal system of segregation was dismantled. But it happened. It's not perfect today, but what a difference it is today from the time that I grew up. Now, that's an example, I think, of our institutions foreseen 200 years ago, that they would try to keep each other in balance, that they try to keep the ship of state on a fairly clear course. Now, on your particular question, and I hope I've made you forget that question, because it's a detailed question that has to do with a current controversy, so I can't really go into it. See, because we're not supposed to answer questions about cases that might come up right in front of us, and usually the reason is because we don't really know the answer yet. And you get the answer out of reading the briefs and listening to the argument and then sitting down and thinking about it. But I can stick with my general answer.